And
Diya,
with your
it's okay,
permission,
right?
Diya, yeah,
Yeah. Go ahead, Shashank. Go ahead, Shashank.
yeah, with your permission, Diya, we are just recording the session. Atmiya does provide recordings to people who miss these sessions. So, if you're okay with it, we'll continue with the recording.
Sure.
Awesome, awesome. This is Shashank Nimmala. I'm from Austin, Texas, and I have been with Atmiya volunteering since last year. Atmiya is a Telugu community organization, and it has a network of nearly 5,000 NRIs here, and also close to 8,000 Indian, back home people who are beneficiaries from the services Atmiya has been doing. Atmiya was previously Best in Fire Academy, which was completely, financial educational platform, and in September 2022, it turned into a NPO, a 501c registered NPO. And with that being said, we have six services basically, key services in Atmiya. We call it Fabric. F is Fire, which is related to stocks, and A is Asra for students here, MS students who come from India, as well as students who study here, high schoolers and all. There are multiple programs, and B is Best, which is all about entrepreneurial education, and R is Real Women, and I is Immigration, which is one premium service where we bring expert lawyers and attorneys, and experts like you, and we help people with their questions and their immigration journey. And C is Community Affairs, which is basically any charity events in India or here. There is a separate a committee for it and a service for it, and we have chairs for it. So shortly, that is about Fabric. And with this being said, I'll turn it to Sunil Patiwada Garu, and he'll take it from here. Thanks, Diya. Thanks for joining, and thanks for taking the call.
Thank you.
Thank you, Shashank. Thanks for that wonderful introduction about our Atmiya and Atmiya family, about our volunteers and back home beneficiaries. Thank you. So, with being said that, we are going to introduce our guest speaker, Diya Mathews, who is a renowned, well-known attorney from Shug Law Firm based out of New Jersey. To give some background about Mathews, I think our audience who have joined very recently, a couple of minutes ago, we've been talking about Mathews' journey, Diya's journey, started from 2004 to 2007 when she pursued her master's in Michigan Law School, I believe. She has got her master's degree from Michigan University in 2007, and she has received her bachelor's degree from Nalsar, India, back in 2004. I believe she is a very key attorney from our Chag law firm based out of New Jersey. And also, one key thing to note here is she's associated with this law firm for a very long time, like 15 years, 8 months. So, such a wonderful journey. That's what we've been discussing before this call. Um, and also, this law firm is majorly focused on business as well as family immigration activities, I believe. So, and also she is a key board member of TIE. TIE stands for like the Indus Entrepreneurs, which actually fosters the entrepreneurship within our Asian Pacific community. I think most of our Indians, Asian, Sri Lankan, Bangladesh, most of these young entrepreneurs, or even the very enthusiastic entrepreneurs, whoever wants to try their luck in the entrepreneurship, I think they do get benefit out of these TIE events, everything. That's what she was mentioning. So with this whole great background, Diya is going to provide her valuable time for with us to, I think, to answer some of our immigration questions. We have a well-defined agenda. I think our Venkat Raju is going to take through that agenda. So, but before to that, Diya, thank you very much for your time. Thanks for your presence. Just before the holidays, I know how busy you could be, but still, thank you. Thanks once again. So, over to
Thank
you,
you.
Venkat Raju.
Thank you,
you.
Sunil, for that kind introduction. Thank you. Happy to.
Thank you, Sunil. Thanks for providing the information. So, since everybody almost joined, so probably people can understand the experience from of the Diya. Thank you, Diya. Thanks a lot. And we have an agenda today, Diya, on our 2024 GC bulletin forecasting. And second one is our domestic visa renewal process. It's a burning point now. The third point is H1B cap for 2025 changes and further immigration questions. So basically we have three. One is GC bulletin for 24 and domestic visas and H1B cap for 2025. So probably we would like to know about all these things. So you can share the details if you have with your handy on these 3 points, and further we can proceed for questions from our friends. Yeah. Thank you, Diya.
That's a long list of topics to cover. So how much time do we have for the session? If I may ask.
Actually, yeah, probably.
Our members want 2 hours call. But it's holiday season and everyone is busy. It's up to you. Sorry, whatever the time permits for you. I don't know. You are our guests, so we want to go away with time. But after that, if they have any questions, they can send email or we can answer it. Thank you.
Right. So very quickly. So we'll start with the visa bulletin, right? And honestly, with the visa bulletin, I'm sure your audience knows better than me. Most of the time, my clients are the ones who alert me when the new bulletin has come out, right? And they've already checked, whether USCIS is using table A or table B. But, for those, who might not know this, there's 2 tables. There is the final action table, which is, we call it table A. And then there is the table B, which is the dates for filing chart. So there are 2 charts that are published by the Department of State, and USCIS gets to decide which chart they're using every month for filing purposes, for adjustment filing purposes. Now, at the beginning of the fiscal year, and the USCIS fiscal year starts in October, right? So usually at the beginning of the fiscal year, starting in October and going on until about March the next year, usually, USCIS will use table B. And table B usually runs ahead of table A. So that means that more people get an opportunity to file their adjustment applications, their I-485 applications. So even though we know that table A, the final action date for those, priority dates are not going to become current anytime soon, at least people are able to file their adjustment and they get a lot of benefits based on that, like EAD and AC-21 portability after a certain period of time. So that's that. Now, the January 2024 visa bulletin was pleasant to see because primarily for EB1 India, the dates had moved forward, at least in table B, the dates had moved forward to 2021, and even table A had moved forward quite a bit. So, earlier it was stuck at 2017 or so, it had gone back quite a bit. And for a long time, it seemed like there was really no option, for Indian nationals. Like there's, really no category which is quick except for EB5, which is not, obviously, it's not accessible to very many people. So EB1 India has shown considerable recovery, and I think that's a good sign. But we don't know. I don't think it is going to continue moving at the same rate because I think that's what people want to know. Can we expect the same rate of movement going forward? I suspect not. And even if you hear Charlie Oppenheim, many of you might have listened to his chats. Earlier when he was working for Department of State, he would have a monthly podcast where he would talk about predictions and movements. Now, of course, he's retired from the Department of State. He works in the private sector, but he still has his projections, his predictions. And even his estimate is that EB1 India will not move forward too much. The same for EB2 and EB3 India. It is currently at 2012. They might move the dates maybe a little further along until the summer of 2024, but not expecting a significant movement. So that's that on the visa bulletin.
Okay.
And then the next question I think was about the
question. I know this. I want to expand on that. One question for me. A lot of people are asking me privately. During the Trump time, he gave an opportunity to using the filing date for, now it's a final action date. You can use the filing date to file it. There's a lot of 10 years, 15 years they're waiting. Is there any government is thinking that, or maybe ILA is at least hearing from the government agencies that do they give an opportunity to do based on the filing date so that everyone can file the 485 adjustment of status? They don't get a green card, at least they get a work permit
They
and
get
everything. They
yeah,
can
there's a
move
lot of
on.
lobbying. Yeah.
What is the, at least on that point? Thank you.
No, that's a great question. Why can't they enable the, everybody, right, with an I-140 approved to be able to file their 485, and at least, they are in the queue that way and they get some benefits like the EAD and portability. So there is a lot of lobbying going on, and you mentioned AILA. So I'm a member of AILA, and in fact, I serve on the committees, the USCIS committee for New Jersey chapter. So we do a lot of work, directly with the on the liaison side with the USCIS. Um, and I mean, it's not it from a regulatory standpoint. There is nothing stopping USCIS from doing it. They could allow everybody to file their 485s and just hold them in queue, right, until the final action date becomes current. Why they're not doing it? I think the way they look at it is that they have staffing issues, they have administrative issues. So generally, when they release Table B, at the beginning of the fiscal year, they think they're going to put the Table B dates based on the total number of visas available for that fiscal year. So they don't, they also tend to be a little conservative. They don't want to release too many, take in too many applications and not be able to manage them. So I think that's why they're not doing it. But to answer your question, I mean, someday we might get there. I think if the lobbying persists, especially, from people, because Indian nationals are the most affected, right? So if there is continued lobbying, we might end up there. So that was a long answer to your short question.
Yeah, thank you. And one last thing, my request from Atmiya is, Atmiya, we can work with the different non-profit organizations and along with attorneys. Can we lobby the government to give at least the people who are living in this country for more than 6 years, or whose 140 is approved, they can file a adjustment of status, at least, not a green card.
Yeah.
Can we do that legally? Can we work with the attorneys and go to the lobby the lawmakers about this? Can we do
We
that?
can lobby for anything, right? So, but when we lobby, there's the way they look at it is there's so many considerations, right? There is the undocumented population, so it's usually a negotiation, right? And so you can, ask for 10 things, and you might end up getting 2 of them. So you have to pick and choose, right? Which are the which are the really high priorities, the ones that we want to get, we want to be successful in. Personally, from dealing with so many clients over the years, what I feel strongly about is children aging out. I feel, when you have been working here, right, let's say somebody comes in their late 20s or early 30s and they're here, and at some point they know they're going to get their green card. Maybe it will take 15 years, 20 years, right? But what, it's really sad for the children, right? Like children who've come here when they were, maybe 3 years old or 4 years old, and then they age out, and then after 21, they have to move to F1, and then they have to get their own H1B. And so that is one of the areas where I feel, I see a lot of Indian clients going through it, and the anguish of the parents, right? Because what are they going to tell their children? Hey, like they've grown up here, but they cannot guarantee them a green card. So that's an area where I feel we should really focus our efforts on, to prevent aging out of, these children who've been here lawfully and who are doing everything right.
Thank you, Diya. Definitely, that is one of the agenda for Atmiya 2024-25 team
Yes.
working on it. We need your help. We need your help, and as a lawyer, you can help us. We can bring all these 5,000 people, 10,000 Indian NRIs, especially kids. We can bring them. They went to the high school, middle school here, and still they are going through the 15 years legally. Their parents are paying the taxes, not getting the work permit
Exactly.
or
Exactly. Yeah.
definitely. Venkat, sorry, Venkat. I want to prolong the agenda.
No problem.
Please go back to you, Venkat. Thank
Yeah,
you.
sure. Thank you, Diya, because EAD under compelling circumstances is the burning point, and EAD for kids also. But there are lots of conditions for kids aged So probably we'll approach you for especially this one. This is the priority. Thank you. And the next one is the domestic visa renewal. So probably we already had some couple of information for India and Canada. So probably you can provide the details on this one.
Right. So yeah, again, they've been releasing information in spurts, and the most updated information that we got as of 2 days ago is that I think it is evident it's really just a pilot program, right? So they're just testing it out. So this is going to be running between I think it's just for 2 months, right? Between January 29th and April 1st. So it's just 2 months, and they will take about 20,000 cases, right? That's what they have said. And the requirement is that the person should have, recently, in the year 2021, they should have gotten an H-1B visa from a consulate in India, or they could have gotten a prior H-1B visa from a consulate in Canada between 2020 and 2023. So, wider time period for visas from Canada. You should not have had administrative processing in your previous visa issuance. So when you've had administrative processing for your previous visa application, you will have a notation on your visa stamp saying clearance received, right? So those cases will not be eligible for the pilot program. And H4s are also not eligible for the pilot program. So this is, as you can see, it is meant to apply to a very narrow group of people who've had H-1B visas without any hiccups in recent times from a consulate in India or in Canada. And the process is that, they would first complete, you can go online, and I think they will have some sort of an intake screen. They will tell you if you're eligible or not. You answer a few questions and they'll tell you if you're eligible for this program or not. If you are deemed to be eligible, then you can put in your application. So they will release a certain number of slots every week. And I think about 5,000 or something every week. So you have to pick one of those. And then, once the quotas or the numbers for that week is used up, then you have to wait until next week. So that's how they will release it. And then they will tell you where to mail your passport and, pick it up. So for those of you who are here, you might have, the US used to have this many years ago, right? About 20 years ago, they used to have this. So it's just, I see you raising your hand.
So that this is interesting point. Like if any candidate having any admin process previously, then
you will be not eligible.
Yeah, I think this should be known before paying the processing fees, so that we can avoid those kind of applications while submitting.
Yeah, I think this will be one of the questions in the the screening questionnaire. But they've also said, like, for any reason, if they take your fee and then they find you ineligible, they will not return your fee. That they have made very clear. So
Diya ji, in that case, candidate can approach you for taking the help, or is it a direct
to complete this? Yes, absolutely. I'm sure many most immigration practitioners would be offering assistance, but I think this is meant to be pretty simple. I think people can do this on their own, but of course we would never say no if somebody needs help.
Usually this happens in a green card interview. So the attorney behind the candidate and helping. So let's see if people having such issues, then we can approach you. Thank you.
Okay. Yeah. And that link is not yet active. So so if anybody is trying to find information, I think they will enable it in a couple of weeks. But they have not enabled that yet.
Yes. Still, we don't see any details, and we will see the details soon.
Yeah.
Okay. Thank you. And H-1B cap 2025 changes.
So the main changes, I think everybody's been talking about it. One is obviously that they're going to change the the way that they run the lottery, right? instead of doing it by the employer, now they will do it based on the beneficiary. So that is good, right? Because I think that will put an end to, this issue with the multiple registrations and people, I heard about somebody who had close to 100 registrations. So, avoid situations like that if they're going to do the selection based on the beneficiary. And then the beneficiary will get to decide which petitioner they want to file the petition with, which company they want to file the H-1B petition with, right? So that is one of the welcome changes that they're proposing. And hopefully they'll implement it by the next, by March, which is usually when the registration will happen, the lottery will happen. There's a few other change. Well, I guess the other change is that the H-1B, the cap gap, the time period for the cap gap, which is when they enable the work authorization between the person's OPT period end date and the start of the H-1B, the H-1B start date. So that basically that meant that the cap gap until now was only until September 30th, right? But now they're going to extend it by another 6 months, and so it will run until April 1st, because as we know, with the cap adjudications and multiple rounds of H-1B lottery, mostly the H-1B start date would not be October 1st, it would get delayed. So the cap gap extension will help a lot of students in that situation. And then I guess the other important change is that the fee, the registration fee currently, which is $10, that is going to most likely go up. We don't know if it will come into effect for the next, for the 2024 registration, probably not. But that is, meant to go up significantly. I think over $200 from current $10.
Nobody is worrying about that initial fees, madam. Nobody.
Nobody. Yeah, I mean, it's easy money for USCIS, right? I think they're going to not have much of a challenge to that.
That's true. Thank you. Anything on student visa? Omji, you can say.
No,
yes.
after you ask the question, I want to further ask on the lottery question.
Yes.
So Venkat, go ahead. You're asking something. Then after that, I can
Any like changes for the multi applications or student visas?
Yeah.
So
Yeah,
So
I'm
would
glad
like
you
to
asked that. As you know, as you might know, the USCIS has just released a policy memo a couple of days ago clarifying a few things with regard to F1 visas for students. One of the welcome changes is that they have said, they have clarified that students, even though you're in student status, there's nothing prohibiting you from applying for a green card. In the past, people would be worried, hey, I'm in F1 status. Can I start a perm now? Can I do my I-140 now? And, we always said you can do that, but you just need to structure it a little carefully, so the I-140, typically we would file it as consular processing, and, there's a few things to be done. So USCIS has, kind of codified that at the moment. The other clarification they have given is that while you are in OPT, and with STEM students, you can get OPT for up to 3 years now. And many of them would be very, many students are entrepreneurial and they want to do their own thing. They want to set, have their own company. And so the question would be whether, they could set up their own company and work for that company while on OPT. And the current guidance, policy guidance clarifies that it is possible to do it. I mean, of course, there are a lot of caveats. You have to show that it is actually an employer-employee relationship. But the good thing is, if it is properly structured, then it can be done. So, I would assume that, the student cannot be the only shareholder for that company, right? But, and then claim to be working for that company, but could be a part shareholder. And as long as you can show a proper board and independent management, the F1 student could potentially own that company, have ownership in that company and still work for that company. So that is, I think a welcome clarification. By the way, I think I should have said this at the beginning, but everything discussed here is for informational purposes and not meant to be taken as legal advice. For anyone, who wants specific legal advice, I always urge you to speak to your practitioner, to your lawyer, and get independent advice. But yeah, from an informational standpoint, this hopefully helps. And also going back to the new H-1B rules, That also, one of the initiatives is that one of the changes is that entrepreneurs can file their own H-1B visas. I think we're still going to be waiting on a few more details, but pretty much they have said that just the fact, and I think there's going to be limit. It's not going to be 3-year approval. It's probably going to be an 18-month approval, but there's nothing stopping an entrepreneur from filing their own petition through their company.
Oh, okay. Thank you.
I have one.
Yeah, again, no, that last one. Again, on that, only if you have the proper board, proper investment, is real startup and everything,
Yeah.
not for the staffing companies. Just I want to clarify on that. If it is staffing company, I don't think. But Diya, can we have, let's say that I got a big project from IBM project for the multi-year contract.
Yeah.
Can I start the one company as an H1B? If
You
it is
want
not a
yeah.
staffing, I mean to say I have a project, a software project, I got it.
Yeah. What USCIS looks for is whether there is really an employment relationship, right? So you could be an owner in the company, and we've had cases where the H-1B beneficiary was an owner in the company, right? Like I think, up to 25% or 33%, they had ownership in the company, it was disclosed. And as long as there is there is other people in the company, right? And this H-1B employee should not be the only one calling the shots, right? As long as it's not
Not exposed.
disguised, as long as it's not disguised self-employment, right? And there's actually a company running there with other people, it should be, you can justify it. So again, it goes back to that whole employer-employee relationship. I had a case, an interesting case, where this person had set up the company in the name of his parents, right? The parents, I think, were green card holders. So his mother and father, they were 50% owners in the company. And he said he's, in reality, he was running the company, but he had just put his parents as the shareholders. And during the site visit, USCIS asked for proof, who's running it, who's making the decisions. And they finally said, hey, it's your parents, and we are not going to look beyond that. It is really you. We know that it is really you. So they revoked the H-1B because, he wasn't able to show that there was, really an independent board or a proper executive team running the company. So, you have to, USCIS has also become very sophisticated. The FDNS investigators also have become pretty smart, and they know what questions to ask, what to look for. So, you have to do things properly.
Thank you. Back to you, Venkat. Sorry, Venkat.
Yeah, thank you. Thank you, Diya. Wonderful answers, and almost 30% of questions were already answered as per my understanding. So, our friends are having a couple of questions. Probably we can go one by one. So Sunil, you there?